State of Ohio versus Tyrone Robinson. We're here for sentencing. Mr. Goodyear, is there a statement from the state?
If you recall, there was a co-defendant named Jamal Lewis in this case. Mr. Lewis pled guilty to almost all the same charges. He did not plead guilty to the participating in gang activity charge that Mr. Robinson did, but he received a 3-year sentence by this court based on the same or similar conduct. I'm certain that Mr. Engel will argue that that somehow should apply to his client as well. I just want to remind the court that the reason why Mr. Lewis received the sentence he did is because his out date already was 2061, and he was basically to spend the rest of his life in prison on aggravated murder charge. So I think the court took into account that special circumstance in deciding to give Mr. Lewis the sentence that he did, which was, I think it was 3 to 4 years that he received. Regarding Mr. Robinson, I'm sure is still now and has been a member of a gang. He's a heartless felon. He tries to act in the PSI like he really doesn't understand why he would be associated with a gang. But there is a multitude of evidence in this case indicating that he is a gang member, including the fact that he acknowledged to ODRC when he was in prison that he was a member of the heartless felon. So when you read the PSI and you see him act like he just doesn't know what you're talking about when you mention gangs, he's lying to you. He commits offense in the furtherance of this gang and that gang's interest, which is why he was charged with the felony 2 that he pled guilty to. We know that he was involved in drone flights at Lebanon Correctional, Lorraine Correctional, North Central, and Madison. Now, I'm sure it probably was more than that, but at the very least, those 4 prisons, he was involved in sending drones in with drugs. Pattern of activity involving a number of different individuals, including Mr. Lewis, including his girlfriend at the time, Miss Boyer, including Mr. Lewis's girlfriend, Miss McQueen, who were the 2 other co-defendants. But this was an extensive conspiracy to get drugs into multiple prisons throughout the state of Ohio. In this case, we know for a fact what drugs they were because the drone crashed when Mr. Robinson ran away after he was almost apprehended. And I don't know the exact words he used, but basically he says he had no idea how much money anybody was making in this activity, acting like somehow he really did. He just was doing this for his buddy. He's got this guy, he's been my friend, and I'm just helping my friend out by sending drugs into the prison. The State Patrol obtained his iCloud account, which had a plethora of pieces of evidence in it, which belie this statement in his PSI. And Judge, I would just point out, it's amazing to me that he would lie in his PSI. I mean, he's here for sentencing. This court has to determine what a sentence is, and he's lying to the court about all this information. He would send Mr. Lewis a video of himself dropping drugs from the drone into the prison, and right after that, he would receive Cash App notices from either Apple Pay or Cash App or a variety of sources, and he was essentially making $5,000 each time he would drop these drugs into the prison. There is a text message from Mr. Robinson to Mr. Lewis, and he talks about when he's going to drop drugs in the prison. And Mr. Lewis's response is, "Perfect, I've got $20,000 waiting for you on Saturday." So he specifically talks about paying Mr. Robinson $20,000 for one weekend, one set of activity on one weekend. So this idea in the PSI that he had no idea anybody's making money, and boy, I'm just doing it for my buddy, is just a complete lie.
Good afternoon, Your Honor.
Good afternoon, ma'am.
My name is Tanika Harrison. I'm Tyrone's mother, and I currently live in Florida now, and it's disturbing that I traveled all this way to be here to hear such horrendous things about my son that are not true. Like, it was hard sitting there listening to those things. My son is not and has never been in a gang. He has made a mistake, and I don't think that he should be crucified for a mistake that he made. I'm not asking for the court to excuse any indiscretions that he has done. He's a great son. He's a great father. He has small children. He's a great help to the entire family. And this is not who he is. Like, it's hard to hear these things about my son because this is not him. And I'm just asking that you take it into consideration that, you know, Tyrone is a very loved person. He loves us as well. And We need him to be here. I need my son, just like he needs us. And I'm asking, for your mercy and leniency in sentencing him today because he's not a monster. Those things that were being said about him are not true. Then I'm just asking that you take that into consideration in your sentencing with him today.
Okay, thank you, ma'am.
My name is Tayana Robinson. I'm Tyrone's little sister. I had a car accident when I was 16. I had 18 facial fractures and my hip broke. I almost died. I wasn't conscious for about 2 weeks, although people told me I still have been talking through that time. But the only thing I can remember is calling for my siblings. Tyrone being the main one. I was told I might not walk for another 6 months at least. Came and visited me a couple times, and I was able to get through my rehab in just a week. About a month and a half or so later, I was walking again. I'm due to have a hip replacement again soon.
There's some tissue there if you need them, ma'am.
I'm due to have a hip replacement again soon. And I'm only 21. And I don't feel like I would have healed as fast if it wasn't for the family I had there with me. We already lost our grandfather, who was another father to us. I can't lose my brother.
My name is Tatiana Johnson. I'm Tyrone's oldest sister. It was really hard to see him come out and change and to hear the charges against him because I know personally that's not who he is as a person. I don't believe that those represent who he is overall. I know him to be very loving and kind and willing to put out a hand and help me, whatever. The type of person who I don't ask him, he'll come and shovel snow every single week for me without asking to make sure I don't do it, to come take my trash out every week. He's a great father and a great person. And I don't think that this is a representation of who he is. I ask that you take those into consideration when thinking about his sentencing today and what he's going to be charged with and how much time he gets. I hope that you can take into consideration that he is more than those horrific charges.
Ma'am, you stated that very well because you didn't say he didn't do these things, you didn't say any of that, but you did reflect the human side and say you're saying that the charges that he's admitted to committing don't represent who he is as a person, and I understand that.
Yeah, that's the side that I don't know of him. I know what is being presented and what you guys have said, but I don't know that.
Okay.
Thank you.
And as the prosecutor noted, the co-defendant received 3 years, and I acknowledge there are different circumstances for that. But I'm hoping the court would consider something towards the lower range. And I say this not because I have any desire to relitigate what the prosecution said. I don't think we need a trial about whether someone's in a gang or not in a gang, or someone knew about a warrant or didn't know about a warrant or anything like that. I think there's two really important facts that I hope the court will consider, and really that's what I want to focus on. Number one is Mr. Robinson is here before you having accepted responsibility. And I think that's important. He's not contesting, as Your Honor noted with a family member, he's not contesting the facts here. He's not contesting that he did something wrong. He's accepting responsibility for what he's done, and he understands it's going to include a prison sentence in there, and he's not asking to get out of that in any way, shape, or form. Second thing is, I'm personally touched by the family support that he's got here. It's rare even that we see a defendant show up with even one person to support them. But the fact that he's got a large group of people here supporting him, I think is a testament to the fact that he has a future. And I hope he uses his time in the prison to take classes and get his degree and do whatever he can do to better himself, because this is the type of person who, if you give an opportunity with a lesser prison sentence, with this type of support, is very likely to make something good out of his life after he serves his time. And that would, I think, be the most important thing that we can take away from here. I'm sure he would like to address you as well, Your Honor.
All right, thank you. Mr. Robinson, is there anything you'd like to say, sir?
Yeah, I know I ain't saying I ain't do these charges. I know I did wrong. This ain't, like she said, this ain't who I am. I've been in prison before. I know I shouldn't be in front of you at all, facing none of these charges, but my last time being in prison, that was 2017. I know how to be on the straight and narrow. I ain't no bad person. I got a lot of small children. I take care of my family. I take care of my kids, spend time with my family. I ain't no hard criminal or no crazy gang member like you trying to make me sound like I am. Like, that's not who I am at all. When these charges came about, I addressed that I am guilty. I just asked that you be lenient on me. You know, I'm sorry that I even got to be in front of you. You know, this won't happen again. I ain't somebody that just always commit crimes or keep committing crimes. He try to make it like it's just that I just haven't got caught. No, it's just that I'm not a criminal. I don't just, it's not who I am. My time is spent on my family and taking care of what I got to take care of in my household. I'm not a person that just be all out in the streets or, you feel me, anything like that. But I feel like I affected my family the most. Like, those who my victims is. I got small children that I gotta go do. I gotta go to prison and be away from that I'm used to spending every day with. I take my kids to school every day. I spend time with my grandmother after my grandfather then died. I ain't no bad person. The charges don't reflect me as a person or who I am as a man.
I know it has to be very difficult to sit and look at your family and realize how much pain you've caused them. On count one, the sentence is 12 months. On count two, the sentence is 6 years. On count three, the sentence is 6 years. I'm sorry, on count three, that merged.
Yes, sir.
On count four, on count seven, the sentence is 6 years. On count eight, the sentence is 6 years. The sentences in this case shall run concurrent for a total sentence of 6 years. He has credit of 111 days.
Quickly point out, because these are felonies of the second and first degree, there would be an indeterminate sentence, so it would be 6 to 9.
Yeah, 6 to 9, I'm sorry, 6
Yes,
to
sir.
9. I'll go over that in just a moment. If you violate the terms of that supervision, the adult parole authority can send you back to prison for 9 months per violation, up to 1/2 your stated sentence, which is 6 to 9 years. What that means is you can get out in 6 years, as long as you stay out of trouble and follow the rules in the prison. Also, if you work toward rehabilitation, take as far as classes, that has a double benefit. It helps prepare you a little more when you're out. If the Department of Corrections chooses to extend your sentence based on your conduct in the prison and the other things I've just described, they could increase it by 6 months at a time, a year at a time, all the way up to 3 years. All right, that's all.
Judge, I'm sorry, did you mention jail time credit?
Yes,
111 days. Okay, thank you.
Yes.
Next matter is State versus Pennington, CR 2024-483. I'll note that Mr. Pennington is present in custody in person. Mr. Feldman, his attorney, is here. Ms. Evans from the county attorney's office is present. Before we went on the record, Ms. Evans indicated that the victims or victims representative were provided with Zoom links. We have not seen them. If they join us, we'll put that on the record. Mr. Feldman, two quick things before we begin. First, your client's parents are here, correct? Yes. Okay, I'll note Mr. Pennington's parents are present. And then Mr. Feldman, I see there's a motion to withdraw. You anticipate that I address that following sentencing?
So I filed on an active secondary case.
Okay, and that's in Division 1, so that case is no longer active?
Correct.
Okay.
Then we filed a notice of appeal.
I'll note for the record that the court has reviewed the pre-sentence report that's dated December 30th by Officer Smith. Mr. Pennington, can you please tell me your full true name, sir?
Sure, Jeffrey Thomas Pennington.
And is he picking up, Madam Clerk? Do we need to move the microphone? What's your date of birth, sir?
70.
Okay, thank you. Based upon a jury finding, it is the judgment of the courts that you're guilty of count 1, sexual conduct with a minor, a dangerous crime against a child, the victim being under the age of 12, committed between January 1st of 2018 and January 1st of 2020. A Class 2, non-dangerous, non-repetitive felony, a dangerous crime against a child. Ms. Evans, would the state like to be heard further beyond what's in your recommendation?
Yes, Your Honor.
Okay, please.
The state wants to point out that there are basically no mitigating factors in this case. Certainly no statutory mitigating factors, not a single one, which leaves him with the catch-all mitigating factor, which there also isn't any. First, there is no remorse. Despite a guilty verdict and being confronted by the overwhelming evidence of his guilt, he still has never accepted any responsibility for these crimes, instead choosing to adamantly declare that he is somehow innocent. The defendant has never expressed any remorse towards the victim. He has never once shown an ounce of empathy or sympathy for the harm that he caused her. He doesn't care. The only care he has ever expressed was for himself. The only things that he has done in this case was declare that he was uncomfortable in the jail, complain about his treatment for his cancer, discuss how he was scratching and making himself bleed. The only person he has ever cared about was himself. And I am positive he will claim that his cancer is a mitigating factor in this case. That this errant coating in his cells that has made them multiply out of control somehow should make his sentence lesser. While Arizona law does not force you to find some sort of causal connection between mitigating factors and his sentence, it does allow you to assign weight if there is no causal connection. So if you somehow find some pity in your heart for his condition, I ask that you give that minimal weight, considering that has no causal connection with his crime. No, Judge, this man is a cancer to the victims. A cancer that continues to eat at her and will continue to eat at her for the foreseeable future. The victim in this case, the one who remembered what he did to her, is still bleeding. The mental anguish he has inflicted upon her is a wound so deep, it has barely begun to heal. That brave teenage girl testified and told you that she was suicidal. A 12-year-old girl wanted to die because of what he did to her when she was 7. Despite all that pain and all that suffering that she continues to go through to this day, she still testified, refusing to suffer in silence any longer. And it was one of the bravest things I have ever witnessed, because up until she actually testified, we were unsure if this would be the right thing to do, if she would be able mentally to come up here and do this, or if we were doing more harm to her than good. But she still managed to do it. And the worst part? The defendant wasn't even done. He wasn't done hurting her. He had a plan to haunt her from beyond the grave. Using his own family. He had a letter in his computer that he planned to have his family deliver to the victim. A thinly concealed bomb to remind her of what he did to her. He would have made his own family unwilling participants in his quest to thoroughly ruin a little girl. And they would have had no idea. Fortunately, he was stopped before he could do that to her, or his family. Not that he cares about his family. There was some evidence he was doing this to his own niece. But he doesn't care about that, because he has the exact opposite of remorse. He fully believes that most people would commit crimes if they didn't get caught. And that's exactly what he tried to do. He tried to get away with it. He tried not to get caught. Because he doesn't understand the very basics of morality. He doesn't understand that something can be wrong and can have consequences for others, even if you don't have somebody else telling you that it's wrong and forcing you to act in compliance with very basic human decency. There is no empathy in him. There is no sympathy in him. And unfortunately, Judge, you can't fix that. You can't rehabilitate that. And no matter what you do, you're not going to give that little girl back her sense of safety. The only thing that you can do is put him in a position where he can never hurt anyone else again. The defendant can't even claim that he had a rough upbringing or there was something in his childhood that caused him to do this. No, by all accounts, he had a great childhood, a stable family, no adverse childhood events to think of. His family did a wonderful job. And his parents are here, and they were here during the trial. And I'm sure they're sitting back there wondering, what did we do wrong? Did we cause this? And the truth is, it's not their fault. But they too are victims because all they can do is sit here and listen to what he's done and bear witness. Because I'm sure they don't condone what he's done, but he's their son. And no matter what, they love him. And finally, there's the other victim in this case, the victim's mother. The mother who entrusted her child to a man that she found at church, a man of God, a man that put himself in a position so that he could do things to her children. And she's sitting there feeling guilty and torn, wondering how she could have missed it. Wondering what she could do more to help her children. This isn't her fault either. She did her best with the options that she had, despite what the victims did, but despite what the defendant did to the victims. The only correct sentence here, Judge, is the absolute maximum term that can be delivered to him. That's all.
Thank you. Okay. Mr. Feldman, I'll hear from you and or your client.
Thank you, Your Honor. My client does not wish to address the court. So with that, Your Honor, we would simply ask the court to follow the statutory requirements under the law, and we'll focus on the appeal.
Okay, thank you. The court's going to make the following aggravator and mitigator findings. I'll find two mitigators, which is the defendant does have family support, has been mentioned. He's been at all of our the family's been at most, if not all, the hearings. I'll also note his physical health as a mitigator. On the aggravator side, the court will find that the jury found that there was victim harm to the victim KD. Additionally, the jury found that both victims were under the age of 12. Beyond that, the court finds additional aggravators of multiple victims in this matter. The court also finds the aggravator that the defendant was in a position of trust, i.e. providing child care for these victims. The court finds that probation is not appropriate and statutorily not available. Considering the aggravators and mitigators that the court has found, The statutory requirement is life, so it is the judgment and sentence of the court that the defendant shall be imprisoned for life. He will have 443 days credit as of today's date. I'll note that he is not eligible for release. Imprisoned for life. He will have 443 days credit as of today's date. I'll note that he is not eligible for release until he has served at least 35 years. And that sentence will date from today's date. I'll order that restitution remain open for 90 days.